Mr. President.
The senator from Rhode Island.
Thank you, Mr. President. After hearing oral arguments earlier today, the Supreme Court will rule on a case that will determine whether average Americans will continue to have an independent federal watchdog to push back against the abuses of big financial institutions. The case I'm speaking of is the Consumer Financial Protection Bureau, CFPB, versus Community Financial Services Association of America. It deals with an outlandish ruling of the Fifth Circuit Court of Appeals that would invalidate the congressionally approved funding scheme of the CFPB. If it stands, the ruling will starve the Bureau of funding and effectively prevent it from working on behalf of the American people. But let's take a step back to remember why the CFPB was created over a decade ago. In the run-up to the Great Recession, lenders were aggressively marketing subprime mortgages with predatory features to borrowers they knew had no ability to pay. Reckless Wall Street firms bundled those mortgages into securities and sold them to investors, including pension funds. And weak regulators stood by as all of this unfolded. Borrowers ultimately discovered that they could not repay their mortgages. The securities backed by these mortgages took a nosedive, causing a meltdown in the banking system and taking down the entire economy. While Wall Street got a lifeline from the Congress and the federal government, millions of Americans did not. They paid with their jobs, their homes, and their savings. The unemployment rate peaked at 10%. Nearly 7.5 million families lost their homes, and Americans lost $20 trillion in household wealth. At the time, people rightfully asked, who was looking out for them? And the truth was, no one really. American families were ill-served by financial regulators and by the system. A half-dozen federal agencies shared responsibility for making sure that working families didn't get ripped off, but they all failed. In many cases, they seemed to regard their primary mission as protecting the big players in the financial system. And they were hamstrung by the Bush administration, which used the appropriations process to starve agencies like the SEC of the resources and personnel they needed to be effective. So while these agencies all had some responsibility for protecting consumers, none of them pursued it vigorously. The performance of regulators at the time put truth to the saying that when everyone is responsible, no one is responsible. This weakness in our regulatory system and structure is why Congress created the CFPB and gave it a singular mission to protect Americans from the worst kinds of financial abuses, not just for mortgages, but for every single consumer financial product. The creation of this agency is arguably the most, or one of the most certainly, reforms made following the financial crisis. Now, I recognize that Wall Street and big financial companies have always feared the CFPB. That's because the CFPB, the Consumer Financial Protection Bureau, is the only financial regulatory agency that exclusively focuses on protecting consumers against abusive practices. But Wall Street also fears the CFPB because its finding and funding structure insulates it from regulatory capture, aggressive lobbying, and political pressure. Wielding its power judiciously and effectively, the CFPB has delivered results for American families. In a little more than a decade, the Bureau has attained $17.5 billion in relief for 200 million consumers. And so, the industry, never giving up on killing the CFPB, the industry hit pay dirt when an activist panel of judges on the Fifth Circuit Court of Appeals issued a bizarre and potentially sweeping decision which invalidates the CFPB's funding structure based on a distortion of the Constitution's appropriations clause. The court's reasoning is flimsy. It relies on a single concurring opinion and a series of law review articles, some of which were written by students. According to Georgetown professor of law Adam Levitan, the argument about the CFPB's funding was a throwaway point in the litigation, with the parties dedicating a paltry 370 words apiece to this issue in their briefs. Unfortunately, the result of the Fifth Circuit's decision are not academic. They are very real for hardworking Americans whose financial well-being is now at risk. If upheld, the Fifth Circuit's ruling would call into question the validity of all the Bureau's past actions. Mr. President, the work of the CFPB matters to ordinary people. It is the only federal agency that supervises mortgage lenders, student lenders, credit reporting bureaus, debt collectors, international money remitters, and auto finance companies. Because there has been a CFPB for the last decade, people in Rhode Island and across the nation have had someone who is working to make sure they will be treated fairly, that their banks and lenders will deal with them honestly, and that their interests would be protected whenever financial institutions try to take advantage of them. And that will change if the Fifth Circuit's ruling stands. I want to particularly highlight what that means for military families, because this has been an aspect of the CFPB's authority that I've been deeply committed to since the beginning. Simply put, without the CFPB, military families will be stripped of their financial protections under the Military Lending Act. The CFPB has brought 40 public enforcement actions involving harm to service members and veterans, securing more than $175 million in relief. The agency plays a unique role in watching out for our nation's 2 million service members and their families, whether they are deployed in the United States or overseas. The CFPB protects members of the armed forces from exploitation at the hands of unscrupulous lenders and debt collectors who have charged service members interest rates as high as 600% and who have threatened to derail their careers if they do not pay up. More than recovering money, the CFPB, through its supervisory powers and by its simple existence, acts as a deterrent. If the Supreme Court shuts it down, predatory lenders will re-offend against our troops again and again and again with little chance of being penalized. The presiding officer understands this very well because as a naval aviator and leader of troops like myself, who is a paratrooper and executive officer, a company commander, we saw all the shenanigans that they were playing downtown, selling the trucks to the young enlisted people for a great bargain, nothing down but 1,000% interest rate almost. We saw them come and take the trucks later when the young soldier, sailor, airman couldn't pay. Time and time again. Finally, through the Military Lending Act and CFPB, we stood up and said this is not fair. And one of the great ironies, of course, if you ever went off base, all of these car dealers and other service agencies had proudly had the American flag waving and all sorts of red, white, and blue, et cetera, while they were systematically, in many cases, stealing from the men and women who protect this country. In a letter written to the Banking Committee Chairman Brown, the Veteran Affairs Committee Chairman Tester, Intelligence Committee Chairman Warner, and myself in February, the CFP director said, "I am gravely concerned that this decision could impact companies' compliance with the Military Lending Act and the federal consumer financial laws that protect service members and their families. The impact would be dire, effectively stripping service members and their families of legal protections that are critical to maintaining military readiness. In the Fifth Circuit alone, which covers Texas, Louisiana, and Mississippi, this could affect 300,000 service members and their families. And, Mr. President, I would like to submit for the record a copy of the letter from the Director of the Consumer Financial Protection Bureau.
Without objection.
Thank you, Mr. President. And the Military Officers Association of America and a dozen veterans organizations have validated the CFPB's strong track record. In their words, all told, the CFPB has become an indispensable agency for protecting the legal rights and financial readiness of service members, veterans, and their families. The stability of the CFPB's funding is therefore vital to the tremendous work it does on their behalf. Finally, let me add that it's not just average Americans who will be put at risk. Responsible lenders will lose the protections of the regulatory safe harbors created by the CFPB. Those rules essentially protect the industry against the risk of enforcement so long as they play by the rules and provide standardized disclosures in plain English. Those responsible actors in our financial system who extend credit on fair terms and deal honestly with their customers have a lot to lose. It all adds up to this. The Fifth Circuit's decision prioritizes the interests of predatory lenders over responsible lenders, relies on falsehoods over facts, and chooses chaos over stability. That's certainly not what any court should be doing. I hope, sincerely, the Supreme Court reverses the Fifth Circuit's dangerous decision. I hope it recognizes that this is not about expensive lawyers and trade associations and big businesses. This is about Americans, many of them wearing the uniform of our country. They deserve the sympathy and the support of the court. Mr. President, I yield the floor. I would also note, Mr. President, the absence of quorum.
Clerk will call the roll.
Ms. Baldwin.
Mr. President, I would ask to dispense with the calling of the quorum.
Without objection.
Thank you, Mr. President. I ask unanimous consent that the Senate proceed to legislative session and be in a period of morning business with senators permitted to speak therein for up to 10 minutes each.
Without objection.
Mr. President, I have one request for a committee to meet during today's session of the Senate. It has the approval of the majority and minority leaders.
Duly noted.
Mr. President, I ask unanimous consent the Senate proceed to the consideration of calendar number 96S, Resolution 156.
The clerk will report.
Calendar number 96, SRES 156, calling on the government of the Russian Federation to release United States citizen Paul Whelan.
Is there objection to proceeding to the measure? Without objection. The Senate will proceed.
Mr. President, I ask unanimous consent the committee reported substitute amendment to the resolution be agreed to, the resolution as amended be agreed to, the committee reported amendment to the preamble be agreed to, the preamble as amended be agreed to, and that the motions to reconsider be considered made and laid upon the table.
Without objection.
Mr. President, I ask unanimous consent that the Senate proceed to the consideration of S Resolution 394, which was submitted earlier today.
The clerk will report.
SRES 394, honoring the life of James L. Buckley, former senator for the state of New York.
Is there objection to proceeding to the measure? Without objection, the Senate will proceed.
Mr. President, I ask unanimous consent the resolution be agreed to, the preamble be agreed to, and that the motions to reconsider be considered made and laid upon the table with no intervening action or debate.
Without objection.
Mr. President, I ask unanimous consent that when the Senate completes its business today, it stand adjourned until under the provisions of Senate Resolution 394 until 10 a.m. on Wednesday, October 4th. That following the prayer and pledge, the Journal of Proceedings be approved to date, the morning hour be deemed expired, the time for the two leaders be reserved for their use later in the day, and morning business be closed. That upon the conclusion of morning business, the Senate proceed to executive session and resume consideration of the O'Brien nomination post-cloture. Further, that all post-cloture time be considered expired at 11:30 a.m. and that following the cloture vote on the Herson nomination, the Senate recess until 2:15 p.m. to allow for the weekly caucus meetings. That if cloture is invoked on the Herson nomination, all time be considered expired at 2:15 p.m., and that if cloture is invoked on the de Klerk nomination, all time be considered expired at 5:30 p.m. Finally, if any nominations are confirmed during Wednesday's session, the motion to reconsider be considered made and laid upon the table, and the President be immediately notified of the Senate's action.
Without objection, so ordered.
If there's no further business to come before the Senate, I ask that it stand adjourned under the previous order.
Under the previous order and pursuant to Senate Res. 390.